Order, order. We start with questions. Secretary of State for Justice, Dr. Luke Evans.
Number one, Mr. Speaker.
Thank you, Mr. Speaker. The reconsideration mechanism was introduced in July 2019, and it's a vital tool for public protection, allowing ministers to intervene in parole cases where there is concern that the decision to release is irrational, procedurally flawed, or where there has been an error of law. Since 2019, this government has used the mechanism to have 17 release decisions retaken by the Parole Board. 9 of these resulted in the Board reversing its original decision to direct release, including the recent case of Colin Pitchfork.
Dr. Luke Evans.
Thank you, Mr. Speaker. The Right Honourable Member for Nuneaton and I have both raised concerns about the release of Edwin Hopkins, the schoolgirl killer of Naomi Smith. Now, I know the Secretary of State can't retrospectively apply the law around parole, but can he assure my constituents and residents in neighbouring Nuneaton that the new laws in the Victim and Prisoners Bill going through Parliament at the moment put public safety at the heart of future Parole Board decisions?
I'm grateful to my honourable friend for raising this extremely troubling case. The murder committed by Edwin Hopkins was a truly dreadful crime, and I understand the concern about the release of prisoners who've committed such heinous offences. The reforms in the Victims and Prisoners Bill do ensure that public safety is at the forefront of parole decisions, including by codifying the release test in law and introducing a new power to allow the Secretary of State to direct a second check on the release of some of the most serious offenders.
Jim Shannon.
Mr. Speaker, can I thank the Lord Chancellor for his response and also for his clear commitment to ensure that those who are victims are considered. In this process, I get, as a Member of Parliament for Strangford, get many people contact me in relation to those who are getting early parole or decisions that are made. Can the Chancellor, Lord Chancellor, reassure me and reassure this House that victims will be considered, victims will be contacted before any person who has carried out an evil crime is actually released? Thank you.
The honourable gentleman is absolutely right. It's one thing being the victim of a crime in the first place, but it's another thing not being kept updated in terms of the progress of the sentence of that individual or indeed a parole decision. That's why we are absolutely committed through the Victims Code and indeed through other mechanisms to ensure that victims are kept updated, including during the important parole process.
Number 2, Mr. Speaker.
Thank you, Mr. Speaker. The House should be in no doubt as to how urgently we are working to accelerate justice. We will have recruited 1,000 new judges by the end of this year, extended the use of 24 Nightingale courtrooms and funded a record number of sitting days in courts last year. We have transformed the way we support victims of sexual violence offences through the criminal justice system, including with the use of nearly 1,000 independent sexual violence advisors, some of those specially for children, the nationwide rollout of Section 28 evidence procedures and pre-court familiarisation for vulnerable witnesses.
Thank you, Mr. Speaker. Mr. Speaker, my constituent had to wait several years before her historic child sexual exploitation case was finally heard. During that time, the trial court date was cancelled twice, causing her immense distress. I appreciate there is a backlog of about 65,000 Crown Court cases, but there's a third more. That's a third more than there was in 2020, and nearly a third of these are waiting more than a year, again, compared to 10% in 2020. So I appreciate what the Minister has said in terms of the additional barristers and judges that are being recruited, but given the sensitive nature of these historic cases, could she indicate what percentage of the backlog is down to this and what specifically she and her team are doing to address this?
I thank the Honourable Lady for her question. It's an issue that she's raised before. She will know that listing is a matter for the independent judiciary, but I don't seek to hide behind that. And actually, I would like to meet with her and discuss the specific reasons why the case she's talking about was adjourned, because I do think there may be something we can do to help. I would just like to draw her attention to 2 things that I think are important. A new police task force that the government set up to support historic child sex abuse investigations has led to a 20% increase in child sex charges in the last year alone. And in addition to this, I would just say this. Greater Manchester currently have 59 live investigations into child sexual abuse. These are complex cases, multiple perpetrators, multiple victims. In one case that recently went all the way through the court, the perpetrators didn't even know each other, they'd never met. So even the decision about how the group is arranged, how the case is allocated, the length of time it will need for listing is particularly complex, but I would like to meet with her for the reasons I've said.
Question 3.
With permission, Mr. Speaker, I'll answer questions 3, 4 and 8 together. Supporting victims has broadly 3 elements. First, it means ensuring harmful behaviour is comprehensively criminalised. That's why we've legislated to create new offences of stalking, coercive and controlling behaviour, upskirting, revenge porn, non-fatal strangulation, cyber-flashing. Second, it means ensuring that the punishment fits the crime. That's why the average sentence has increased by around 50% since 2010. But third, it means supporting victims both before, during and after the court process. That's why we're funding over 1,000 ISVAs and IDVAs by 2024-25. We've set up a 24/7 rape support helpline and we're quadrupling funding for victim services in cash terms since 2010.
Thank you. Cuckooing is not a victimless crime. The victims whose homes are invaded are frequently extremely vulnerable. Will the Secretary of State consider a separate, specific offence of cuckooing in the Criminal Justice Bill to ensure not just that the punishment fits the crime, but that the crime fits the crime?
Well, the Honourable Lady has been brilliant about this, raising this issue time and time again, and at least in part because of the pressure that she has put on, we have held a stakeholder engagement exercise on this issue with the police, with CJS partners, with local authorities, other government departments and so on. And the exercise reveals that there are civil orders and criminal offences which are available to disrupt it. It might be, for example, that the underlying offence is a possession of drugs with intent to supply. It might be possession of firearms. There could be common assault, etc. But I do think this is worthy of further consideration, so I would invite a conversation with her in due course.
Dr. James Davies.
Thank you, Mr. Speaker. Last week I was contacted by a constituent who has been named in the local press as a victim of domestic abuse against their expressed wishes. As my right honourable friend will appreciate, this naming has the potential to endanger their safety and harm their recovery. So what more can be done to safeguard the confidentiality of victims of domestic abuse?
My honourable friend raises an absolutely essential point because it is a deeply traumatic experience going through giving evidence. Now, there are powers that exist. It's Section 46 of the Youth Justice and Criminal Evidence Act 1999, which means that the court can, on application, make a decision about anonymity, and they take account of the circumstances of the alleged offending, the circumstances of the alleged offender, and indeed the alleged victim, and so on. That is, of course, a matter for the court. The court will have to weigh the circumstances of that case as against the overarching interest of transparency. That is a matter that the courts are well placed to decide upon.
Mr. Speaker, Carshalton and Wallington is supposed to be one of the safest parts of London, but has been shocked by a number of knife and violent crime incidents recently, including a knife attack in Wallington Sainsbury's on Christmas Eve, which was not only traumatic for those involved, but those who witnessed it. So could I ask my right honourable friend to assure me that victims and witnesses of these terrible crimes can get access to help and support whilst they're waiting for the police to build a case?
Can I thank my honourable friend for drawing the House's attention to this appalling incident? Yes, it is absolutely imperative that both victims and witnesses can access support in the aftermath of such shocking crimes. As I indicated, we're quadrupling funding for victims and witness support by 2024-25 on 2010 levels. But this is important. Under the 2006 Victims Code we inherited, support was only available for direct victims, but we've changed that so that it's now available for witnesses who've suffered mental or emotional harm.
Thank
you, Mr. Speaker. The Government left the role of Victims Commission unfilled for over a year and to this day refused to place any duty on public bodies to cooperate with the post holder. Can the Government and the Secretary of State explain why they have not supported Labour's proposals to give the role the same powers as a Domestic Abuse Commissioner over public authorities like the police?
The Victims Commissioner plays an important role, and we are delighted that Baroness Newlove is taking on this role again. She has a track record which is exemplary, and it sits within a wider approach that we are taking, which is to ensure through the Victims and Prisoners Bill, through the revised Victims Code and so on, that victims going from being spectators of the criminal justice process to participants in it. And I know the Victims Commissioner will help us on that journey.
Gregory Campbell.
Mr. Speaker, what's been done to ensure that victims of crime, particularly violent crime, get the type of necessary mental health support that they require, particularly where they can suffer ongoing mental health issues and trauma beyond the period of the crime itself?
Gentleman raises an absolutely essential point. As I indicated, we are quadrupling funding for victim services on 2010 levels. Now, part of that is directed through police and crime commissioners to procure and commission precisely the kind of support that he's indicated. What I'm also able to say is in those tragic cases which result in a fatality, the homicide service is now better resourced to provide that ongoing support, which may be physical support, but it may also, sadly, be the mental support that they desperately need.
Andy Slaughter.
Number 5, Mr. Speaker.
Thank you very much, Mr. Speaker. In December of last year, we completed an estate-wide programme of surveys to assess the condition of each public sector prison, and I look forward to the findings of that. By the end of this spending review period, we will have invested nearly £4 billion towards the delivery of an additional 20,000 modern prison places to ensure the right conditions are in place to rehabilitate prisoners, and in the last full financial year spent over £200 million on maintenance and upgrades, alongside, of course, our continued investment in purposeful activity within the prison estate.
Thank you, Speaker. I was delighted to receive an invitation from the Minister's colleague, the Honourable Member for Orpington, to join him on a visit to Wormwood Scrubs Prison in my constituency this Thursday. Less delighted when the invitation was withdrawn yesterday as issued in error. Had I been permitted to attend, I would have raised the letter sent on the 7th of December to the Lord Chancellor by 10 chairs of independent monitoring boards for London area prisons, including Wormwood Scrubs, which stated prisons are overcrowded, not safe, and most of those in prison do not lead a useful life. In the absence of a reply to that letter, could the Prisons Minister tell us how he intends to make prisons fit for rehabilitation when, according to trade union sources, there's a maintenance backlog of £3 billion?
To the honourable gentleman, in not issuing this one in error, if he would like to visit the Scrubs with me, I'm very happy to accompany him on a visit to his local prison. What I would say to him is that, as I highlighted, we continue to invest in our prison estate. We continue to invest in increasing numbers of prison officers, and I take the opportunity to pay tribute to them for the work they do day in, day out, something I suspect the opposition front bench would join me in saying, and the investment we're putting into purposeful activity across the estate, and the efforts we've put in across the estate are working, as seen by the proportion of prison leavers in employment 6 months after their release, which has more than doubled in the 2 years to March 2023. But I look forward to discussing this further with him in his local prison.
Can I just say, members of Parliament should be treated as a member of Parliament with a prison in their area. I do find it disappointing that that was withdrawn from a member of Parliament, that visit. I do hope it will be investigated to why a member of Parliament has been refused access to something within their constituency. Please.
I understand from my honourable friend that the invitation was sent in error by the office. It was not meant to be sent, but I'm happy to honour the invitation.
Because I'm concerned about members of Parliament having access. Sir Robert, Chair of the Select.
Thank you, Mr. Speaker. I won't comment about how I might have got people into Wormwood Scrubs in the past, one way or another. I'm out, yeah, absolutely. But I'm sure the Minister will know that one of the key themes that comes up time and time again in Her Majesty's Chief Inspector of Prisons reports and issues raised by the Justice Committee is this lack of purposeful activity. And the physical estate is part of that problem, but so are issues around staffing, so is the issue of around access to education and other provision. Is it perhaps time for a strategy for the whole of the prison service with rehabilitation at its centre? And might an answer to that be to look perhaps to introduce a statutory definition of the purposes of prison, of which rehabilitation, along with protection of the public, will be one of those key parts to hold people's feet to the fire to actually deliver rehabilitation in the public interest?
Thank you, Mr. Speaker. Well, I'm grateful to the honourable and learned gentleman. I'm certainly happy to have that discussion with him if he feels that would be particularly useful. I'd highlight that staffing in the past year has increased by 6.7%. He's right to highlight the importance of adequate staff numbers in prisons. And I'm happy to tell him that this month we are launching the national regime model, which will require institutions, prisons, to set out ambitious plans for dedicated purposeful activity, time out of cell, to hold their feet to the fire over delivering that regime, which, as we know, is central to rehabilitation.
We come to Shadow Minister Ruth Cadbury.
Thank you, Mr. Speaker. Mr. Speaker, the latest figures show that the reoffending rate for those leaving prison has increased. This is in part because prison is failing to rehabilitate, and this is no surprise when we've seen how overcrowded, understaffed and dangerously unsafe many prisons are. In one case, after heavy rain, prison officers were having to wade through raw sewage while prisoners remained locked in their cells. Does the Minister accept that the appalling state of our prisons are not only failing to reduce crime, but breeding it?
I'm grateful to the Honourable Lady. She won't be surprised to know that, no, I don't agree with her assessments. I'd highlight that reoffending rates are down on where they were when we inherited them in 2010. I've highlighted to the Honourable Lady both the investment in new staff and in our buildings. But I'd also highlight to the Honourable Lady, and I hope we'll enjoy her support on this, the success of tough community sentences in reducing reoffending compared to sentences of fewer than 12 months. So I look forward to her support in delivering those changes.
Thank you, Mr. Speaker. I'm going to remain on the prison estate because the Minister made a valiant attempt to defend the Conservatives' woeful record in prisons, but they are failing to build the prison spaces we need to reduce this cycle of crime. Just last week, it was revealed the government had built only 380 of the 1,000 pop-up prison cells they promised by the end of 2023. Therefore, can the Minister, at the very least, confirm when the remaining 620 pop-up places will be built?
I'm grateful to the Honourable Lady, but I would gently say to her, we'll take no lessons from the party opposite on prison building, the party that promised 3 Titan prisons, 7,500 places. How many built? 0. This is a government that's committed to building 20,000 new state-of-the-art prison places. 2 prisons have already been built. 1 is in construction. 1 has just received planning permission, and I'm hopeful that the other 2 of the 6 will receive that in due course.
Jack Brereton.
Number 6, Mr. Speaker.
Thank you, Mr. Speaker. Last year we spent £1 billion on civil legal aid to support the most vulnerable, and we recognise the potential benefits of early legal advice in supporting people to resolve their problems earlier. For example, last year we launched a £10 million housing loss prevention advice service. We invested in advice for welfare benefits issues, and early legal advice is also available for victims of domestic abuse in private family law proceedings as subject to the relevant means and evidence requirements. We will continue to invest in legal aid where we can see a benefit.
Thank you, Mr. Speaker, and I thank the Minister for that response. Like many members across this House, I regularly have constituents coming to me with many legal issues, needing legal advice and support. And obviously, many members are not appropriately qualified. We're not qualified to offer that legal advice and support. Citizens and Advice in Stoke-on-Trent are doing an excellent job trying to support many of my constituents with legal issues. But would my right honourable friend agree that it's vitally important that members of the public get timely and affordable legal advice when they need it?
Thank you, Mr. Speaker. My honourable friend is right to praise the work of organisations like Citizens Advice, and we agree that investing, as I said in my original answer, does pay benefits. And that's why, since 2015, we've invested more than £25 million in support for litigants in persons, including our current grant funding programme, the £10.4 million improving outcomes through legal support grants. That is supporting 59 organisations across England and Wales, enabling them to provide early legal support and advice to help people resolve their legal problems. That is in addition to the investment in providing support for domestic violence, special guardianship orders, housing loss prevention and on immigration.
Thank you, Mr. Speaker, and good morning, Mr. Speaker. In their Green Paper published in October 2023, the Law Society set out reforms to legal aid to help more people get early advice. Can the Justice Secretary confirm what discussions he has had with the Treasury in advance of the budget in March regarding potential increases to the legal aid budget, and that Scotland will receive its share through Barnett consequentials?
Mr. Speaker, I can confirm that following the Bellamy report and the implementation of what's known as the Clark Review, we have invested over £141 million extra in the legal aid system, addressing many of the concerns that legal practitioners, including the Law Society, have implemented. And I can reassure the gentleman that I'm in constant dialogue with the Law Society on how we can improve legal advice to the citizens.
Stuart C. MacDonald.
Yeah.
Your leave, Mr. Speaker, I will answer questions 7, 9, 19 and 23 together. The United Kingdom has a long-standing tradition of ensuring rights and liberties are protected domestically and of fulfilling our international human rights obligations. We remain committed to a human rights framework that is up-to-date, fit for purpose and works for the British people. We have taken and are taking action to address specific issues with the Human Rights Act, including through the Illegal Migration Act 2023, the Victims and Prisoners Bill and the Overseas Operations Act, which addressed vexatious claims against veterans and the armed forces.
Thank you, Mr. Speaker. The Rwanda Bill is the second piece of legislation that his government has introduced, which he cannot guarantee will comply with vital convention rights. And doesn't that illustrate exactly the total inadequacy of UK human rights legislation? Any old government, even a crumbling Tory government, can rip up fundamental rights without constraint, doing over the Supreme Court in the process.
No, we reject that characterisation. So the European Convention on Human Rights under Article 13 requires a right to an effective remedy. We think there is a perfectly respectable argument that our legislation fulfils that. We are committed to human rights, and we think that we have a route which safeguards those rights and delivers on the interests of the British people.
Stephen Bonner.
Thank you very much. Mr. Speaker, the Human Rights Campaign organisation Just Fair have hailed the Human Rights Bill for Scotland as providing a blueprint on how the UK as a whole could proceed, enshrining social, economic and cultural rights into domestic law. I'm certain that the Scottish Government in this area would be happy to share their experience and expertise. So will the Secretary of State commit to engaging with the Scottish Government with a view to bringing forward equivalent UK legislation following in their example?
Well, I completely agree, of course, of the common interest we share across the United Kingdom of wanting to advance social and economic rights, which, put another way, is to ensure that there are good jobs and there are good public services. Of course that's right. What is questionable about is whether it's sensible to make those rights justiciable. In other words, to find people pursuing all sorts of actions in the court which clogs them up, as opposed to them being able to deal with all sorts of other matters. So he's right on the principle, what we all want to achieve for our people in our country. Is he right on on more litigation and more legislation? I think we'd have different views on that.
Hello, Badal.
Thank you very much, Mr. Speaker. The Scottish Government will bring forward a human rights bill for Scotland. That is the right thing to do. But given his previous statements in support of human rights and the ECHR, will the Justice Secretary confirm his support for the Scottish approach? Because surely putting human rights at the heart of government and the wider public sector is the right thing to do.
It's really important not to conflate two things. So we are members of the European Convention on Human Rights, and I already mentioned Article 13. But that does not in and of itself determine how one should give effect to them. So we already have the Human Rights Act. It's not at all clear to me that a human rights bill has been proposed in Scotland would indeed advance human rights across the United Kingdom. But of course, we will listen carefully to whatever it is the Scottish Government decides it wants to introduce.
Martin Docker to use.
I'm sure the Minister is aware, Mr. Speaker, the ECHR and the HRA are integral to the Good Friday Belfast Agreement, setting out a framework for policing and also for the very governance of Northern Ireland. Does the Secretary of State agree that any attempts to overhaul the ECHR and HRA from this place could have serious consequences for the communities of Northern Ireland?
So, as I say, we have a human rights framework which we consider to be important. We are mindful of the points that he raises. As I say, we are satisfied that we can deliver on the priorities of the British people, and it's a perfectly reasonable priority to want to ensure that we have warm hearts but an open front door. We're satisfied we can do so within our international legal obligations.
It was revealed yesterday that despite the best efforts of the Home Office, an Albanian-speaking migrant from Serbia who spent half his life in Serbia, who's been jailed in this country for 18 months for cannabis farming after having entered the UK illegally, has been allowed to remain in Britain after he successfully claimed that he couldn't be deported to Serbia because he no longer speaks Serbian. This is despite Albanian being a recognised minority language in Serbia, and he lives in this country with his Serbian brother. Doesn't this demonstrate why we need urgent reform of the asylum system and human rights laws to allow the rapid and effective deportation of dangerous criminals such as this?
So my honourable friend is absolutely right. Those who come to our country but betray the trust of this nation by acting illegally should not expect a warm welcome. That's why one of the things I'm most proud of is we've signed a further prisoner transfer agreement with the Albanians, which ensures that the British people, having suffered the initial crime, don't suffer the double punishment of having to pay £49,000 a year to house them in bed and breakfast in the United Kingdom. We'll send them back. That's exactly what we're doing.
SNP spokesperson Chris Stevens.
Thank you very much, Mr Speaker. If I can take the Justice Secretary back to the Rwanda Bill and the statements he's made, which were interesting observations that he made, particularly around the ECHR, which he has said has been the whole debate around the ECHR has been tainted by a misunderstanding of what the actual rights are, as though there are some foreign imports that do not reflect some of the cultural norms in the UK. And he went further and said that nothing could be further from the truth. Why then, when it comes to the Rwanda Bill, is he failing to uphold the ECHR and the Human Rights Act, which embody so many of the legal principles that the people of these islands hold so dear?
I respectfully completely reject that characterisation. We are remaining within the four corners of our international legal obligations, and we're doing so with legislation which is, yes, novel, which is, yes, contentious, but remains within the four corners of our international legal obligations, delivers on the proper insistent requirements of the British people, which is that we protect our borders and we ensure, by the way, fairness for all, fairness for the British people, but also fairness for those who played by the rules and done the right thing when they've come to the UK. They will always have a warm welcome in our country. Those who act illegally can expect short shrift.
Thank you very much, Mr Speaker. Of course, the front of the Rwanda Bill actually says that they can't guarantee that it complies with ECHR, as he very well knows. Now, that bill also makes direct intrusions into devolved areas because human rights are devolved to the Scottish Parliament. So, can he confirm that there will be a legislative consent motion that will be sought from the Scottish Parliament on the safety of Rwanda Bill?
So the first point he was referring to is the Section 19(1)(b) statement. Section 19(1)(b) statements are not unusual. There was one that the much missed Tessa Jowell took through the Communications Act in 2003. There's nothing unusual about that, and that's precisely why it was put on the face of the Human Rights Act. As for further legislative consent motions, we will of course proceed in the normal way, and I'll give that matter further consideration.
Sir Desmond Swain.
Number 10, sir.
Thank you, Mr Speaker. A 2019 MOJ analysis of a matched cohort of 30,000 offenders shows that those serving sentences of immediate custody of less than 12 months reoffend more often than similar offenders serving a sentence in the community. 55% of those sentenced to less than 12 months immediate custody were convicted in the following 12 months, compared to 32% serving their sentence in the community.
Sir Desmond.
For years, I was a visitor at the Scrubs and at HMP Wandsworth. Persuade me that community sentences can be really tough.
I would suggest, Mr Speaker, that the outcome speaks for itself.
Shabana Mapahudi.
Thank you, Mr Speaker. There are going to be many, many more offenders serving their sentences in the community as a result of the measures in the upcoming sentencing bill. And we all know that the government have had to rush these measures out to deal with the prisons capacity crisis that they have created. But it's essential to recognise that these measures will rely heavily on a functioning probation service. So with only one of the 33 probation delivery units inspected being rated as good and all others requiring improvement or inadequate, what additional resources have been put in place to ensure that potentially dangerous criminals are being properly monitored?
Thank you, Mr Speaker. We have recently increased the budget for probation by £155 million, and we have ramped up recruitment with an additional 4,000 staff recruited over the last period of time.
Mr Speaker, that's a 4-year-old announcement dressed up as something new, and I'm afraid, given the extensive changes in the sentencing bill, it just won't cut it, Mr Speaker, because under the Conservatives, our vital probation service has been taken to the brink of collapse, and on current performance, the service simply cannot handle the additional pressure that these measures will bring and keep the public safe. So will the Minister commit to ensuring that the measures in the sentencing bill will not come into effect until there is not one probation delivery unit that is still rated as inadequate?
I thank the Honourable Lady for her question. This is something that we'll keep under review as the sentencing bill passes through the House, and we'll make further announcements in due course.
John Stevenson.
Number 11, Mr Speaker, and can I also draw the House to the register of interest and the fact that I am a practising solicitor?
Thank you, Mr Speaker. The last 12 months have seen the largest volume of probate applications received by the service since 2006, and that follows 2 years of above-average receipts. In response, we've increased staffing levels by over 100 people, we have streamlined processes, and I have to say that we have seen some improvement in that the level of grants issued has been running at about 8,000 more over the past 2 months than receipts. And so the average mean length time for a grant of probate following receipt of all documents required is now 12 weeks.
John Stevenson.
Thank you. Back in November 2020, I led a Westminster Hall debate highlighting the failings of the probate service, a service which was once excellent, but is still no longer the case. And I could give many examples today demonstrating the continuing failures of the probate service. I do appreciate the efforts that the Minister has been making to improve the service. However, I believe enough is enough. If the service is not materially improved in the next 3 months, will the Minister take the appropriate action and remove those who are clearly underperforming so that the service can return to the level it once was at?
Thank you, Mr. Speaker. My honourable friend and I have had some interesting discussions on this topic over the past few months, and I can reassure him that following a new recovery plan to address the concerns that he and others have raised, there is a new management team in place, and we are now seeing a distinct improvement in both in terms of the recruitment, the competency, the actual productivity, and as I've said, we've seen a significant improvement in call handling, but also the fact that we are now seeing disposals outstrip receipts for the last few months. So I appreciate the service is not where we would want it to be, but I would reassure my friend that we are starting to see some impact of the measures we have taken, but I'm more than happy to have conversations with him where we can work together to improve the service further.
Views.
12, Mr. Speaker.
Thank you, Mr. Speaker. With permission, I will answer questions 12 and 20 together. We remain committed to reducing the Crown Court outstanding caseload, and have introduced a range of measures to achieve the same. We've funded over 100,000 sitting days the last financial year and plan to deliver the same this year. Thanks to our investment in judicial recruitment, we expect to recruit over 1,000 judges across all jurisdictions, and we're investing over £220 million over the next 2 years, which will not just improve maintenance, but will ensure that the number of courts taken out of action for unplanned maintenance is reduced.
Mr. Speaker, I'm reassured by that answer, but can I press the Minister on other delays in the justice system? For example, I've spoken to police officers who are incredibly frustrated by the delay in prosecuting those that they've arrested for multiple offences of shoplifting. What reassurance can the Minister offer to police officers in those circumstances?
Thank you, Mr. Speaker. I was obviously concerned to hear that police officers remain concerned. Some of the latest performance statistics would suggest that the gap between charge and first listing is actually falling. It's down 2 days to 31 days on the latest data. But I'm more than happy to meet with my honourable friend to discuss any local issues that he may have identified, to see if there's any local issues that are causing delays. Because I have to say, Mr. Speaker, magistrates which tend to deal with shoplifting cases are one of the most efficient parts of our justice system, and they do actually list cases and clear cases incredibly rapidly. So I'm more than happy to discuss this further.
Jazz Watley.
Thank you, Mr. Speaker. In light of the Post Office scandal, does my honourable friend agree that it's not just imperative that we clear the backlog as quickly as possible, because there have been deaths involved, but also enable the Justice Secretary next to him to strip the Post Office of its powers to independently prosecute?
Thank you, Mr. Speaker. My honourable friend raises a good point. It's vital that the delivery of justice is not only swift, but the wait for trial can be extremely difficult for victims, and that has to be appreciated. So we are doing all we can to ensure cases are heard more swiftly. We are urgently working on the detail of how to clear the names of the postmasters as quickly as possible. Further details will be announced in due course, and there should be no disparity between the standard of justice in private and public prosecutions, and will carefully consider the findings of Sir Wyn Williams' inquiry.
Shadow Minister Alex Cunningham.
Thank you very much, Mr. Speaker. The latest criminal court statistics showed a Crown Court backlog of 66,547 cases, once again breaking records. The next quarter has just ended. Is he expecting to break records again?
Thank you, Mr. Speaker. Well, I can reassure the honourable gentleman that in addition to all the measures we've already taken of unlimited sitting days, of the recruitment of justice, of judges, but also investments on the courts to ensure that our courts are resilient, extending Nightingale courts, I can also reassure him that we are building 58 new courtrooms to ensure that we have capacity. But in terms of the backlog, I haven't seen the figures, but I can reassure him that the number of disposals, the latest figures, the latest disposals are up. I have to tell him that our courts are working flat out and our judges are working flat out, as are all members of the criminal justice system. And I have to reassure him that the level of disposals being undertaken by our judiciary are up and the work they do is exemplary.
Stephen Hammond.
Number 13, please, sir.
Thank you very much, Mr. Speaker. I'm grateful to my honourable friend. Between 2010-11 and 2020-2021, the overall proven reoffending rate decreased from 31.6% to 24.4%. The government is continuing to take action to drive down this reoffending rate even further by investing in initiatives to get more offenders into work, stable accommodation and substance misuse treatment on their release.
Can I thank my right honourable friend for that answer? He's absolutely right that the key to rehabilitation and reoffending is employment and stable accommodation. He has spoken already about purposeful activity today, but can I ask him to look at making the subsistence payment available to all prisoners on release, because that would ensure access to that sort of settled accommodation which is required.
Well, I'm grateful to my honourable friend. He makes an interesting suggestion. I'm happy to meet with him if that will be helpful to him to discuss further his ideas on this.
And Carden.
Mr. Speaker, can I refer to my entry in the register, which is my involvement with organisations related to addiction and recovery. I want to acknowledge the positives of rolling out incentivised substance-free living wings. However, these don't offer recovery as part of the process. Recovery wings offer a far greater chance of rehabilitation and getting people into recovery whilst in prison before their release. There's currently only 7 planned across the prison estate, and I think it'll take ministers to challenge civil servants and the NHS fund holders to see these rolled out across the estate. So could I ask the Minister to examine the benefits of expanding recovery wings across the whole prison estate?
Well, I'm grateful to the honourable gentleman both for his question and for the tone in which he asks it. He's absolutely right to highlight the importance of this. As he'll be aware, those 7 wings are a relatively new step forward. We're seeing how they operate. I think, if I recall, they were initiative by the former Deputy Prime Minister when he was in post in the Ministry of Justice. It's something I continue to look at very carefully, but I'm watching to see how those wings operate first. But I do so with an open mind.
Mr. Roberts.
Thank you, Mr. Speaker. Protecting the public is our top priority. Offenders are subject to strict licence conditions on release, which can include tagging, exclusion zones, and they can, of course, be returned to prison if they breach those conditions. Victims of violent and sexual offenders serving prison sentences of 12 months or more are legally entitled to request protective licence conditions on release, including exclusion zones. The Probation Service works with partners, including police, under the MAPA arrangements to closely manage the risk presented by the most serious offenders.
Roberts.
Rhiannon Bragg's attacker was convicted of stalking, possessing a firearm and making threats to kill. A parole board decided its probation release plan couldn't ensure public protection only 2 months ago, yet he will be automatically released next month. Mr. Speaker, I have sent numerous letters to ministers on this matter, but I haven't received a single reply. Given that she lives in a remote area, which makes conventional surveillance methods virtually impossible, will he finally provide a credible response to the urgent safety risks faced by victims like Rhiannon?
Thank you. Well, can I, first of all, thank the Honourable Lady for raising this case. I do know about the case of Rhiannon Bragg. In the interest of complete transparency, I should say I was at school with Rhiannon Bragg. The government introduced extended determinate sentences to better protect the public from dangerous offenders by making their early release dependent on the parole board. Offenders on extended determinate sentences must be released. There's no legal power, as the Honourable Lady knows, to hold them for longer at the end of that custodial term. But they face years of strict supervision by the Probation Service with strict licence conditions such as exclusion zones and curfews. They will be returned to prison if they breach them. I'm aware of the letter that was sent on the 14th to Minister Arger. He will, of course, be very happy to meet the Honourable Lady to discuss these points.
Smith.
Question 15, Mr. Speaker.
Thank you, Mr Speaker. We've increased funding for the probation service by £155 million a year to recruit more staff, bring down caseloads and deliver better supervision of offenders in the community. We've also accelerated recruitment of trainee probation officers, particularly in areas with the most significant staffing challenges, and as a result, over 4,000 trainees have started on training courses between April 2020 and March of last year.
Councillor Smith.
Mr Speaker, probation workloads are too high and this is having a terrible impact on both staff morale and retention as well as public safety. So what consideration has the Minister given to the very reasonable proposal agreed between HMPPS and the probation unions to free up staff time by abolishing the post-sentence supervision which was brought in under privatisation and is seen as simply a waste of time by both probation officers and their employer?
Well, I'm grateful to the Honourable Lady. She raises an important point. While on partial data for this year, caseloads are going down, they are still, she's absolutely right to highlight it, they're still high. She raises a very specific point about post-sentence supervision requirements, and I think she makes a good point. It's something I'm happy to reflect on carefully, and I understand that my right honourable friend, the Lord Chancellor, has actually met with them to hear their views on this.
Question number 16.
You again. Thank you very much, Mr Speaker. We are committed to improving mental health outcomes for prisoners, including recruiting additional staff, because that is important, having adequate staffing in prisons, investing £625,000 of funding each year until March 2025 to the Samaritans, which includes the delivery of the listener scheme, and working alongside NHS England, who are responsible for delivering mental health support services in the custodial estate, to ensure that they are joined up and effective.
Thank you, Mr Speaker. I have been working with a constituent whose son sadly took his own life in Pentonville last year. While it is well established that among prisoners there is a high rate of mental health problems, the provision of support is insufficient and even reliable data on the scale of the issue is lacking. Will the Government commit to a full review of the support and safeguarding for prisoners with mental health problems?
Well, I'm grateful to the Honourable Lady, and I hope through her I can pass on my sympathies and condolences to her constituents. I'm not aware of the details of that case, but if she wants to write to me about that, I'm happy to look at that specific case. There are sadly too many deaths in custody. Every one is a tragedy. So I'm always happy to look at ways in which we can better improve the support that is available to those with mental health conditions or other health conditions that may make them more vulnerable within a custodial environment.
We'll come to topicals. Mike Kane.
Topical one, sir.
Mr Speaker, first let me thank, if I may, the many HMPPS and HMCTS staff who continue to work hard over the Christmas period to deliver justice and keep us safe. Since the last Justice Questions, the Victims and Prisoners Bill has passed its third reading in this House. It will enshrine the overarching principles of the Victims Code in law. It will establish a permanent independent public advocate for victims of major incidents, and it will enable a second check on parole board decisions in the interests of public safety. The Sentencing Bill, which is cracking down on the worst offenders by extending whole life orders for any murder involving sexual or sadistic conduct, also passed its second reading, as did the Criminal Justice Bill, which will ensure, amongst other things, that criminals face up to the consequences of their appalling actions by requiring them to attend their sentencing hearings. Finally, in December, I took part in a park run at HMP only, alongside prison staff and serving prisoners. Congratulations to all who took part, except perhaps my private secretary, who had the audacity to beat me.
Okay.
The Minister mentioned sexual offences, but it frustrates me beyond belief that my constituents have to wait on average 839 days for their cases to be heard. Is the distress caused taken into account, or is the system too broken?
The Honourable Gentleman is absolutely right to raise the issue of victims of serious sexual offences. We take this incredibly seriously, and that's why we've introduced measures such as Section 28, which enables evidence to be taken and recorded in advance. We've increased the fees for barristers to make that more straightforward. We've also increased the number of independent sexual violence advisors who accompany, as it were, those victims on that journey, and that is very, very important to prevent dropout rates. But we've also, and this is an important point, the sentencing levels are much higher, up by 30% compared to 2010.
Alan Kearns.
Thank you, Mr Speaker. And can I draw your attention to the register of members' interest in that my wife is an education lawyer.
Parents appealing decisions in relation to education, health and care plans and educational health needs are currently forced to wait 9 to 13 months from appeal registration to hearing. This is far too long in terms of the relations of a child's development. And does my right honourable friend agree with that? But does he also share my concern that some schools are using that in the delaying providing education, health and care plans in the knowledge that it will take a year or more in order to have an appeal?
Thank you, Mr. Speaker. My right honourable friend is right, and despite Senate appeals and disposals being up by 24% and 29% respectively, I do share the concerns, and systematic reform is required, and that's why through the Send and Alternative Provision Improvement Plan, DfE and ourselves will be working hard to ensure it's improved. I'm more than happy to meet with my right honourable friend to go through the details.
Minister Janet David.
Thank you, Mr. Speaker. The Children's Commissioner report on family contact in the youth estate states at the weekend in 2 young offenders institutes, boys spend only up to 1 hour outside of their cell each day. So we can clearly see why this has led to an increase in violence. So what is the Minister going to do about it?
It's very important to note that in the time since we've been in power, since 2010, the number of under-18s in custody has dropped dramatically, so that the cohort that is now in Young Offender Institute is, putting it politely, highly, highly complex. Now, of course, we take it extremely seriously. We want to ensure that there is sufficient staff because we don't give up on people. But it's also important to recognise that that cohort will have been convicted of extremely serious offences, and we want to ensure that there are sufficient resources to try to get the best out of them.
James David.
Mr. Speaker, I recently met the senior coroner for my area about concerns over health services in North Wales and to discuss preventable deaths. As part of this work, he pointed me towards the Preventable Deaths Tracker, set up by Dr. Georgia Richards in Oxford. Would the Secretary of State commit to meeting Dr. Richards and me to discuss the potential benefits of this tracker?
Thank you, Mr. Speaker. My honourable friend raised a good point. My officials have already met with Dr. Richards, discussed her work on the tracker, and together with the Chief Coroner's Office, we're already exploring with her team how best to share the tracker on the various websites. But I'm more than happy to meet with my honourable friend and the doctor to discuss how we can work further.
Thank you, Mr. Speaker. Numerous studies have found that the numbers of women being held on remand is disproportionately high for minoritised and migrant women. For example, 10% of female, black and Asian defendants were remanded in custody by magistrates' courts, compared to 7% of white women. What steps is the government taking to address these clear inequalities in the use of remand?
Minister.
Well, I'm grateful to the honourable lady. She'll be aware of the work that's being done across the criminal justice system, both through the Race Disparity Review and also the LAMI review in this context. Decisions on remand are taken by the judiciary, so it would be wrong for me to comment on judicial decisions. But if she wishes, I'm happy to meet with her or with my honourable friend who covers disparity in the justice system to discuss this further, if that would be helpful to her.
Hammond.
Secretary of State confirm that the Director of Public Prosecutions could take over a private prosecution and discontinue it?
Yes.
Thank you, Mr. Speaker. The Crown Prosecution Service can take over any criminal prosecution and may then carry out the prosecution. It may end or discontinue the prosecution if it does not believe that it should have been brought in the first place.
Chris Law.
Thank you, Mr. Speaker. I'm pleased to say the latest Scottish Crime and Justice Survey has shown that the volume of crime in Scotland, including incidents not reported to police, has fallen by 53%. And in addition, we have one of the lowest levels of recorded crime in Scotland since 1974, which is 50 years. I'd just like to add my thanks also to all those who work at Police Tayside for their duty and service on behalf of my constituents in Dundee. So will the Justice Secretary join me in congratulating Police Scotland and all the community safety partners who have contributed to the success?
We, of course, welcome any reduction in crime, and I'm happy to congratulate Police Scotland for their work. It's encouraging that across the United Kingdom, and certainly across England and Wales, crime is down and reoffending is down. If you will allow me the opportunity, I would urge, however, the honourable gentleman to make sure that we don't do anything in Scotland which I think would be regrettable, such as rowing back on jury trials. It does seem to me that that's a critically important part of maintaining public confidence in the criminal justice systems.
Go on. Dr Luke Evans.
Having worked in A&E over Christmas periods over the years, I've seen the outcome of alcohol-related violence and the injuries that it causes. I know the department's been looking at fitting alcohol monitoring to tags for offenders over the festive season. What assessment has the government made of the effectiveness of this in reducing alcohol-fuelled crime?
Very grateful to the honourable gentleman for raising this point. Alcohol tags are hugely valuable. They're being used increasingly to successfully tackle alcohol-related offending, including violent crime. Around 2,800 individuals were wearing an alcohol tag at the end of November 2023, which is 900 more than the same period the year before. And alcohol bans imposed for community sentences are complied with for 97.3% of the days monitored since their introduction in October 2020. They're a vital crime-fighting tool.
Thank you very much, Mr Speaker. In May 2022, my constituent, Tallulah Cox, was diagnosed with brainstem cancer. She was left catatonic from the radiation treatment, a side effect her parents, Zoe and Richard, were never informed of. They then had to constantly fight for the support and care she needed from our local council and NHS. That support never came. Little Tallulah passed away on the 2nd of November last year.
Order. It's a topical question. I've got to get everybody else in. If you're going to do a topical, it's got to be short and quick to allow others. Has the Minister's got a brief on what's been asked? Very quickly, please, just ask the question.
Little Tallulah passed away on the 2nd of November last year, aged 2, after these services failed her. How can her parents get some justice?
This sounds like an absolutely appalling case, and my heart goes out to Tallulah and her family. I'm unaware of the details of this case. If she writes to me, she'll get a response.
Ken Foster.
Thank you, Mr Speaker. Dozens of businesses have signed up to Torbay Council's new Safety of Women at Night Charter, being championed by Councillor Hayley Tranter. What steps is the government taking to ensure that those who are a threat to women, for example by spiking drinks, get the type of deterrent sentence this disgraceful behaviour deserves?
Thank you, Mr Speaker. Well, I thank my honourable friend for his question, and I congratulate Torbay Council and Councillor Tranter on her excellent work to keep women safe in Torbay. Spiking is a disgusting crime that carries a maximum sentence of 10 years in prison, depending on the harm that results. We are changing the Offences Against the Person Act to define the offence of spiking specifically and comprehensively in law, with a view to encouraging more people to come forward. But I have to say, the biggest barrier to conviction remains the fact that toxicology tests are often conducted after the substance has left a woman's body, and that is why we're investing in research for rapid drinks testing kits so that it will be easier to prove and we get more of these offenders behind bars.
Thank you, Leah.
Thank you, Mr Speaker. My constituent was the victim of a violent attack. Because the perpetrator got a sentence of less than 12 months, she wasn't told when he was released from prison. The police say it's impossible for them to go through all the records of everybody released to advise her. So there's a gap here in terms of victim support. And I wonder if the Secretary of State would commit to looking at how to resolve that.
Yeah. Well, I think the Honourable Lady raises an important point. Of course, I take that extremely seriously. I mean, it's certainly the case that under the Victims' Code, the rights of victims to be kept informed are far tighter than ever they used to be. If there's further we need to go, it seems to be a sensible conversation. I'll be happy to have it.
For too many years, Mr Speaker, this House has been witness to wrongful convictions in the Post Office Fujitsu scandal. There remains 800 Post Office convictions based on bad data. Until those convictions are overturned, the victims cannot claim compensation. We can do something good, Mr Speaker, together, if the Justice Secretary would bring a simple bill to quash all 800 immediately.
I'm very grateful to the right honourable gentleman who, with his customary precision, puts his finger on this appalling injustice. The suggestion he made is receiving active consideration. I expect to be able to make further announcements shortly.
John Cryer.
Thank you, Mr. Speaker. Could I add my support to the earlier comments by the member for Hertford and Stortford? Cooking is a terrible activity. Making it a specific crime not only makes sense, but I suspect would lead to the prosecution of other crimes such as drug dealing.
Well, as I indicated, I'm going to have a conversation with my honourable friend about that. It's right, there is very likely to be a substantive underlying offence, whether it's handling stolen goods, whether it's possession with intent to supply, whether it's firearms matters. So this has been considered by way of discussions with criminal justice partners, but if there's further matters to consider with my honourable friend and indeed the honourable gentleman, I'd be happy to have those conversations.
Bailey.
January is often considered family breakdown month, and anybody taking the terrifically difficult decision to separate this year will not only face an average of over 14 grand for divorce, but also months or potentially over a year to resolve children and financial disputes. We need reform and focus in a range of areas. Will the Lord Chancellor kindly agree to meet me and the formidable Baronesses Deach and Shackleton to look at our campaigns?
My honourable friend raises a very good point. I know she campaigns tirelessly on this issue. I'm more than happy to arrange a meeting with my noble Lord, Lord Bellamy, who leads on this issue, to ensure that we update her, and noble Lord Deach to ensure that
Speaker, to reduce reoffending, we need a strong, locally focused, standalone probation service, similar to how things were before privatisation. So why is the government moving in the opposite direction with its 1HMPPS programme, which has triggered a formal dispute with the probation unions because it subsumes probation still further into prisons?
Well, I'm grateful to the honourable gentleman. It's nice to be answering questions from him again, which I did when he was Shadow Secretary of State. The 1HMPPS programme is about different parts of the system working well together to create a system that delivers the outcomes society wants to see. And I would take the opportunity to pay tribute to all the staff actually in the probation service. He's prompted me on that. I had the pleasure of visiting them in Southwark recently, and I pay tribute to all the work they're doing.
Mr. Speaker, in a perfect world, the victims of the Horizons IT scandal would have their cases individually assessed by the Criminal Cases Review Commission and the Court of Appeal. But we're not in a perfect world, Mr. Speaker. The scale of this miscarriage of justice is enormous, and there are understandably hundreds of victims who do not want to come forward because they've lost faith in the process. Will my right honourable friend now consider the exceptional and unique step of legislating to quash the convictions?
I'm very grateful to my right honourable friend who speaks with such authority. These were truly exceptional circumstances. When I was a backbencher, I was on the record as saying this is the most serious miscarriage of justice since the Guildford 4 or the Birmingham 6. But the clue is there were 4 in the Guildford case, there were 6 in the Birmingham cases. We are talking about hundreds. It is truly exceptional, it is truly unprecedented, and it will need an appropriate resolution.
Legal Immigration Act, victims of human trafficking who arrive in the UK via irregular routes would not have legal recourse to receive support under modern slavery provisions. Are ministers comfortable with that? They don't look like monsters, so I assume not. If not, what will they do about it?
Mr. Speaker, I will have to write to the honourable gentleman and check exactly what provisions of legal aid under the Illegal Migration Act provide. I'm more than happy to provide with the details and meet with him if necessary.
Sir Robert Neal.
Precisely because legislating to overturn convictions will be so unprecedented, would my right honourable friend Lord Chancellor make sure that before such step is taken, he is satisfied in conversation with the senior judiciary that the means that currently exist of triaging and consolidating appeals may not be capable of delivering justice within an acceptable timeframe?
That is precisely the point, and he puts his finger on it. So, of course, we would not want to stray into the normal lane of the judiciary. We have huge respect for our independent judiciary, who do an exceptionally good job of ensuring that there is fairness on the facts before them. As I say, this is wholly unprecedented. We will want to have exhausted all alternatives before taking radical action.
Final question on this law.
Thank you very much, Speaker. Spending on housing legal aid has fallen by more than half in the last decade, from 44 to 20 million. Is this a proper response to growing insecurity, overcrowding and poor conditions in the housing market, or might it be a contributing factor?
I have to say to the honourable gentleman that we just last year invested an extra £10 million in housing legal aid, so I think we are addressing the issue.
Right, that completes questions. We'll just let the... Just bear with me. Those who need to leave, please do so. If not, I will then take the point of order. Alex Cunningham.
Thank you very much, Mr. Speaker. On a point of order, the Financial Times